a few of you were in Peoria, so don't cheat on this exercise that I'm about to do. If you'd indulge me, I'm going to clap, and if you can clap with me, you'll see what we're going to do. Okay, so I'll start. Anticipation. That's part of what you want to do as a business owner, is you may think that you know what is coming, but in reality, we know this from experience, life often throws us curveballs. And so it's preparing for that space when things stop and you don't anticipate it, that using business planning can be very effective. And the question that I've got for you is, who's good at what they do? It's not a rhetorical question. Yeah, I think I'd include myself in that. I think we all feel like we're good at what we do. And who would, if you had the opportunity, who would refer business to themselves? I would refer people to me as well. Is being good at what you do enough to be able to help you as a business person? And what I'm getting at is part of what Michael Gerber talks about, in that you may be a very good technician at what you do in your business, but that doesn't necessarily make you a good business person. Michael Gerber wrote a book a number of years ago called The E-Myth, and when it was written, E was not electronic, so that you wouldn't think of it in that way. The E stands for the entrepreneurial myth. And what he talks about is that many people start businesses and they think of themselves as entrepreneurs. And what he mentions is, and I think it's very true, I certainly have felt that way about myself at times, that we may be very good technicians, but that doesn't necessarily make us entrepreneurs. We may be people who are good technicians, but we've had what he calls an entrepreneurial seizure. And I think that's really accurate. If you think about some of the business people that you may have known, some of those people where you just are kind of wondering, how in the world did you become so successful in spite of yourself? That's something that we can plan for. And so that's part of what I want to talk about today. So first, I wanted to talk about the differing types of business entities that there are, and the importance of deciding what it is that you want to be in your business. And there's not necessarily a right answer here. It's in a lot of ways what you're comfortable with. And so I've listed here some typical types of business entities: a sole proprietorship, a partnership involving 2 or more people, a corporation, and then there's the limited liability company. That's a creation of the last 15 years or so, which is kind of a hybrid between corporations and partnerships, and allows some additional flexibility that you don't have when it comes to corporations. So a sole proprietorship, as you can see, one person owns everything. So if I set up my law business and it's Tom Durphy, attorney at law, then I have my shingle out there and I'm on the hook. So the advantages of that is I can just start doing business. If I'm going to come up with a different name other than my own, I may have to register that fictitious name with the Secretary of State, But beyond that, there really aren't any formalities. I can just get a business license if it's required and start doing business. As an owner, I can do whatever it is that I want. And I don't have to answer to anybody. The disadvantage is, though, that the owner is personally liable for whatever debts that the business may incur, whatever liabilities that the business may incur. And so I am exposing myself to some potential liability in terms of damages. If I as an attorney do something wrong and someone sues me for malpractice and I'm a sole proprietor, then all of my personal assets are at risk. So depending on what your tolerance for risk is and just how good you think you are at what you do, that may determine what type of a business entity you want to select. And I've got the note here that a creditor can satisfy a claim out of the owner's personal assets. And what I mean by that is, if someone gets a judgment against you as a business owner, then they can, when you are a sole proprietor, go to your individual bank account and garnish the bank account to satisfy the judgment that they have. If you have a car that you own free and clear, I used to work as a debt collector, believe it or not, and one of my favorite tactics was for people who were not doing what I politely asked them to do, maybe not keeping their promises. What I really enjoyed doing was sending the sheriff out to their house to pick up their car. People tend to move very quickly when their car is about to be towed away. And so they would come up with payments for me to help kind of put things off a little bit. And so that's something that creditors can do if you are a sole proprietor and would end up with a judgment against you. There's more to planning for these types of entities than simply getting a business license and hanging out a shingle. The next entity that I wanted to talk about is a general partnership. You've got two individuals who engage in business and agree to split the profits and the liabilities. This doesn't require any kind of notification to the Secretary of State. If you are going to operate as a general partnership, it would be a good idea to have an agreement between you and your partner or partners that says, this is what we're going to do. I'm going to contribute so much money. The other party maybe is going to contribute sweat equity. Here's how we're going to divide the profits and the liabilities. And if things don't work out, here's how we're going to end the business. So that framework is something that's useful for any of these entities that we're talking about, where you're specifying what are my responsibilities as a business owner and what are my obligations to you as my business partner, and setting those things out so that everybody knows what page that the other person is on. Partnership is not a distinct legal entity, so each partner is going to have to prosecute or defend any lawsuit that they may want to bring. Partners are jointly and severally liable, and by that what I mean is that I can sue both of you, get a judgment against both of you, but then I can go against the person with the money, not the sweat equity, and collect the entire judgment from them. So even though you may have said we're going to split the profits and the liabilities 50-50, I get as the creditor to go in and be able to recover from the person that's got the money, because that as a creditor is ultimately what I'm interested in. And I talk about a lot of these things because of my background, one, in collections before I became an attorney, but also from the background that I have in doing litigation. I tend, when people come in, to talk about what the end game is. What's the worst possible scenario that we could be dealing with? Because that's what we want to plan for. When people come in and they want to start a business, a lot of times it's like a new relationship. And I'll tell them this, things are great right now. All those things that he does are really cute, and I think he's just adorable. And then in 2 weeks, you're like, what in the world was I thinking? Why did I hear that awful thing that he does? It's so annoying. And that's really true. I've known some people in business who've been very good friends, and they've started in business and operated for just a couple of months and found out, you know what? Being in business with him is not like being his friend. So I want to go back to being his friend, and I'll go find somebody else to be in business with. And so that's part of what I try and get people to understand, is that I'm not someone who focuses on doom and gloom, but we are talking about money and we're talking about business. And so you need to be able to separate those business elements from the personal elements and make sure that you plan accordingly. Here are some advantages and disadvantages of the general partnership. Again, it's flexibility, because you aren't required to have meetings at any particular time. You don't need to have minutes for the proceedings of the business as it goes along. You don't need to meet at all if you don't want to. The disadvantages, as I mentioned, partners are individually liable. Also, in the absence of an agreement that provides something to the contrary, if you don't provide for what I have up here as continuity of operations, if a partner withdraws or a partner dies, it's very likely that the partnership comes to an end and you need to dissolve it. And so you want to make sure that you plan so that the business continues and is ongoing and not coming to an end prematurely. The next form, corporations, they're separate entities. And what they have is limited liabilities for the obligations of the corporation. Part of the reason why you would set this up is so that the corporation is, as the entity, is responsible for its own obligations. Unlike in the partnership model, where you have the individuals responsible for the particular debts and obligations of the business, for a corporation, we want that entity to be responsible. And for the same, not only for the business debts, but also if there are liabilities where someone gets hurt and they hire Mark to sue the corporation, then you want the corporation to be responsible for that and not the individual shareholders. The good thing about a corporation is that it can own property. So you can have the property held in the name of the corporation rather than the individual's names if you were talking about a partnership. Some advantages of corporations, they're perpetual. What you mainly need to do is, with the Secretary of State each year, you need to file a report that keeps the corporation going. So if someone withdraws or you sell shares of the corporation isn't going to stop doing business. As I mentioned, it's got limited liability. So you've got people who can protect themselves and are looking to protect themselves through the corporate form. The disadvantages, I've got formalities required. And what that means is, because a corporation is this separate and distinct entity, you've got to maintain that entity apart from yourself. So it can't be your personal piggy bank to dip into and to pay various things whenever you need. For a corporation, you need to establish a board of directors. Now, the board of directors could end up being one person, depending on the size of the corporation. But you need bylaws and articles of incorporation that say, this is our corporation and this is how we're going to operate. You need to hold, unlike the partnership or the proprietorship, you need to hold regular meetings. And that could be, depending on what the bylaws say, that could be an annual meeting. And again, if you're one person, you don't need to necessarily rent out this conference room that we're in and have a meeting and start using Robert's Rules of Order and following things so formally. But what you do need, and it's something that a good attorney can help you with, is that every year you go through and look at, what has my corporation done? And let's list that, and then we will essentially have a meeting on paper that shows that we met and that these are the various things that were done. And where that becomes important is mainly in the area of litigation, because if there's some problem and you've been operating your corporation for 10 years, but for the last 9 years you haven't been holding the meetings, you haven't been doing the necessary corporate action that's required, then that's the point where a good attorney on the other side is going to say, well, you aren't really a corporation at all. You're not doing the things that a corporation is required to do. And so as a result, we should be able to go after your assets personally. And there's a legal term for that. It's called piercing the corporate veil. Basically what that means is, it says you haven't acted like this separate person that a corporation is supposed to be. And because of that, we then should be able to get your personal assets and be able to satisfy whatever judgment it is that we have against you. The last part about the formalities is, only people who are authorized should sign documents related to the corporation. Because again, you want to maintain that this is a separate entity. And if anybody can sign on behalf of the corporation, you have a problem down the line. You're going to have a hard time defending that, no, this was really a separate corporation, because you've ended up merging the personal and the corporate. So that's all part of maintaining the fiction of a separate entity. And I've got down here that as a disadvantage, it's taxed twice. It can be taxed twice if it's a C corporation. And essentially what that means is that if you don't plan correctly, you can be taxed at the corporation level. And then when the corporation has money that flows through to you, it can then be taxed to you as income. And so you want to make sure that as you're setting things up, that you do that correctly. Now, a different type of corporation is an S corporation, and essentially what that is, it's an election under the Internal Revenue Code, which I know you all have sitting by your nightstands and read regularly to make sure that you know what the latest is that the IRS is doing. If you are, I have a counselor or two that I could recommend that you see. It's just basically something that allows the income to not be taxed at the corporate level. And so the S corporation is a decent form to have if you're going to be talking about a small corporation, one that's going to involve a few shareholders. And that way you can essentially allow the taxes basically to be paid by the shareholders. As I mentioned, it's designed for small businesses, and according to the IRS, that's basically 75 shareholders or less. And so I think once you get into tens of shareholders, a lot of times you may be looking at a different corporate form, just depending on how complicated the entity is that you're setting up. And the other important thing with S corporations is that all of the shareholders must consent to the S corp election. So again, for planning purposes, if you're looking at what entity you want to do and you've got 5 potential shareholders, all of them are going to need to consent. And if not, then you probably need to figure out a different corporate form. I mentioned the tax provisions, and basically it's described as a pass-through. It's taxed for you at an individual level, and it's related to the income, the gain, the loss, the deductions, those types of things. The deductions and the losses depend on few things that really aren't important for what we're talking about. That would be something that I would want to have a more in-depth conversation about and probably involve your accountant for even more stimulating conversation between the lawyer and the accountant. So that's something that you can look forward to. As I talked about at the outset, the limited liability company is a hybrid between a partnership and a corporation. What it does is it imports the liability protection that the corporation offers, but allows the flexibility of the partnership taxation that a partnership has. So it gives some flexibility to the members of the limited liability company. And that's something, it's just a difference in terminology, that LLCs don't have shareholders, they have members, and you divide the membership interest just based on what the percentages are that people may agree on with respect to the contributions that they may make. Advantages to a limited liability company: it can own property. It can be managed directly by the owners. So if you have members managing the LLC, they can basically make those decisions as to how the company is going to go forward. As I mentioned, it allows the tax treatment for a partnership, which is often more beneficial than if you're talking about corporate taxation. It is perpetual as well, and in Missouri anyway, you aren't required to file an annual report for an LLC. So being perpetual and not having to fill out the forms for the Secretary of State is a good advantage for some people. With LLCs, you do want to make sure that you have an operating agreement. I've had it happen probably 5 or 6 times in the last 6 months where I've met somebody who owns an LLC, talked to them a little bit, and they say, yeah, I have an LLC, and I'll ask them, that's great. Do you have an operating agreement? And they'll say, what's that? And I'll tell them an operating agreement is the thing that basically makes you an LLC. And they'll respond, well, I went to the Secretary of State's website and I filed my articles of organization, so I'm an LLC. The articles of organization and the operating agreement are 2 different things. The operating agreement says this is how I'm going to run my business. Doesn't get filed with the Secretary of State, but under the statute that creates LLCs, if you do not have an operating agreement, then we go back to one of those first slides and you are unwittingly operating as a sole proprietor and you don't have the liability protection that you were hoping for when you filled out the forms with the Secretary of State. And all of your assets are personally at stake. You want to also be aware with LLCs that there is a potential securities issue because you may be selling interests in the LLC. If you choose what's called the manager-managed option, essentially what you have is an interest in a company where someone else, namely the manager, is making money for you while you are sitting back as a passive investor. And you just want to make sure that if you are having multiple interests in a manager-managed LLC, that someone's looked at, do we have a securities issue? These are a couple of things to consider for planning generally. You want to look at where you want your business to be in the future. You want to make sure you know how it is that you plan to grow. You want to make sure that you invest in the appropriate documents. So you have a good partnership agreement if you're a partnership, that you have bylaws and an operating agreement if you are a corporation or an LLC. If you're in business with somebody else, whether it's a partnership, whether it's an LLC, whether it's a corporation, you want to have a strong buy-sell agreement. Something that says, if we want to get out of this business, how is it that we're going to do that? How are we going to value this business that we hope becomes a multi-million-dollar enterprise? So are we going to have enough cash on hand to buy out the other person's interest? If not, then we better prepare for being able to pay them over time with a promissory note. You just want to make sure that if you're investing your time and your money in a business, that you're not shortchanging yourself. And you want to have a good relationship with an accountant and have the appropriate commercial insurance to provide the defense that you need in the event that you're sued. Because I like lawyers, I get along with them really well, but they aren't cheap. And especially in litigation, costs mount very, very quickly. And so having the insurance to be able to make sure that you're protected is very important. So I mentioned some of the agreements. If you've got customers or representatives, salespeople that are meeting with your customers, a non-compete and a non-solicitation agreement for your salespeople is something that you want to consider, because for those customers that you have, those salespeople are the face of your company. And without that, the salesperson could set up shop down the street and start marketing to your customers. And again, if you spent all your time and money setting this up, the last thing you want is for someone to be able to take what you've built and move people away from you. So I hope this has been helpful as a primer on basic business planning. And if I can be of any help or you have questions later on, I'll be around. Thank you.